Today, not only is Auntie Bev going to tell Jackson to calm down, sir.
Please calm down.
Calm down. You're also going to see how Auntie Bev is bending over backwards to protect Caitlin Albert's relationship with firefighter McLaughlin, Katie McLaughlin. Folks, it's just so obvious. You're going to see her testimony and Katie McLaughlin's testimony are mirror images that match perfectly. Let's get into the sidebars.
It doesn't say anything new.
You must follow the law.
He was present, so I think he can answer whether or not it happened or not.
Have you had any conversation with the prosecutor?
I could say the same thing by taking Amber Heard as a client.
Mentative, don't you think?
Oh, hardly.
Are you able to estimate of those 1,000 different types of cases dealing with accident reconstruction?
We're not with the jury present. That was a step.
Have you reached a verdict?
We, the jury, find the defendant not guilty.
Not guilty.
Not guilty.
Not guilty.
Not guilty.
Well, hello everybody, and welcome back to Buckle Up. It's the Law with Attorney Larry Forman. Folks, today we're going to continue with Brian Albert and Caitlin Albert from Day 10, Massachusetts versus Karen Reed, May of 2024. Sidebars. AI enhanced for our viewing pleasure. Shout out to the trial channel. Let's continue. We just finished voir dire. Let's see what Auntie Bev has to say. I want to let you all know that I have officially started a brand new channel called The Art of Conquest. My face is not going to be on there. These are my ideas, my thoughts, and my lessons that I want to impart onto the world. You're more than welcome to subscribe to that channel. Go check it out right now as I'm recording this. I don't think it has even in the double digits yet.
All right, Mr. Jackson, go right ahead.
Thank you, Your Honor. Mr. Albert, you were notified
The jury's back in the room, by the way.
by the Commonwealth that on September 23rd, 2022, a judge specifically ordered you to preserve that phone and all its data, the phone ending in 0888. Is that right?
Yeah, at what time are you asking me that I was notified?
That day or the next?
On the 23rd?
On the 23rd or the 24th of September?
No.
Isn't it true that you were provided a letter by the Commonwealth that stated the following? Your Honor, if I may read this.
Yes, there's no objection.
Thank you. Quote, you are hereby notified that the defense in the case of Commonwealth versus Karen Reed, Norfolk Superior Court criminal case number 22-117, has filed a motion pursuant to Mass R. Crim P. 17 for the production of any cell phones that you used between January 28, 2022 and February 28, 2022, and or any data associated with those cell phones. The hearing on Ms. Reed's motion will be held on October 3rd, 2022 at 2 p.m. in courtroom 1 of the Norfolk Superior Court. You may be heard on the motion at that time. You are hereby placed on notice that these cell phones are the subject of pending litigation, and you must not alter, delete, destroy, or in any way manipulate any of the electronic data associated with the cell phone at issue. You received, end quote, you received that notice on either the 23rd or the 24th. Is that right?
I did not.
Your Honor, I would pose a stipulation. I spoke with counsel off the record, if I may.
You both have a stipulation that I haven't seen?
We just determined I'm happy to approach it.
Why don't we approach quickly?
All right, here we go. They both agree, so the judge should not interfere.
What is the stipulation?
Mr. Lally was kind enough to confirm that he and his office did send this notice either on the 23rd or the 24th of September.
Okay, so that it was sent, but not that it was received?
Correct. I can't make him read it. They don't have a copy of the letter that was sent. I think a stipulation is cleaner. I simply want to enter into the record that the Commonwealth sent it. If he claims he never got it, so be it.
Okay, so what exactly was the stipulation? What are you going to say?
I would propose the following stipulation, that the Commonwealth on either September 23rd or September 24th, 2022, sent a letter on Commonwealth letterhead stating exactly what was just read into the record.
Okay, don't read it again.
I won't. No, 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 no. That what was just read into the record was sent to Mr. Albert on either the 23rd or the 24th.
Okay, that's the stipulation.
That's it.
That's fine. I don't have an issue with that.
Okay.
Thank you.
May I? Yes. I would offer the following stipulation that on either September 23rd or September 24th, the Commonwealth sent a letter on Commonwealth letterhead to Mr. Albert's attention, stating exactly what was just read into the record pursuant to the court order dated September 23rd, 2022.
Okay. All right, next question.
Now, of course, Brian can always deny, like, I never received it. But everybody is in agreement that it was sent. That's the most important part. Now the jury's going to be like, seriously? You're going to receive paperwork from the prosecutor's office and you're just going to be like, I never received that? Okay, that's on you, bud.
Isn't it true that you were, in fact, ordered to preserve your cell phone by the Commonwealth?
At some point, I was made aware of that, yes.
All right, let's just get to the brass tacks. Where's your phone?
My phone was upgraded and traded in for a new phone.
Your phone was upgraded and traded in for a new phone?
Yes.
Okay. Another way to say that is you traded your phone in and got rid of it, correct?
I traded my phone and upgraded it, yes.
When did you get rid of your phone ending in 0888?
I upgraded my phone in September, third week of September, maybe around 22nd.
Oh, so one day before I got the letter from the Commonwealth, which I never received nor ever read, I just randomly happened to go to the Apple store, and after 3 or 4 years of having the same phone, thought, you know what? I think today would be a good day to upgrade my phone, and the next day I got the letter, which I never received. Oh my goodness, what a coinky dink. I upgraded at the perfect time. I destroyed evidence before I was ordered to preserve it. Man, I'm lucky. Really? That's your... I forgot all about this.
End of September.
I believe so. I can't be sure the exact date.
So, according to you,
this is
you
gold.
got rid of the phone that was the subject of a court order preservation the day before it was ordered preserved. Right?
Rephrase the question, please?
This order was just stipulated, this order.
Or they were tipped off. Somebody in the prosecutor's office was like, hey, we're going to be sending these letters tomorrow. And then one of the police officers or whatever, somebody overheard and was like, hey, Brian, you're going to get this letter tomorrow. You might want to do something about that. Oh, okay. I'm going to go to the store right now.
Dated September 23rd, 2022. It was just stipulated that on the 23rd or 24th, you were then sent a notice to preserve the phone. And your testimony is on the 22nd, the day before this all happened, you upgraded your phone and got rid of it in total, correct?
I upgraded my phone on and around the 22nd, yes.
And you knew that all of the data on that phone would be factory reset and destroyed.
Objection.
Do you know that, sir?
I do not know that.
How many times have you upgraded your phone and your iPhone?
I'm not sure. 4 or 5 times, maybe.
You're aware that when you turn a phone in and you upgrade it, the phone that you turn in, that data is factory reset, meaning it's gone. It's destroyed off of that device, correct?
If you choose to do so, Jackson, sometimes you can preserve it. You can ask, especially if you're getting a similar phone, you can preserve that data, actually. Like I said in the previous video, you can actually have the data transfer unless you say, no, I don't want the data transferred, in which case it is destroyed. And that's what Brian Albert did, obviously.
It transfers and some doesn't.
We're not talking about a backup. I'm talking about the physical phone. That physical phone becomes a brick when you turn it in, correct?
Correct that it becomes a brick? I don't know.
It becomes effectively a brick. There is no data left on the phone. I'm not talking about backup data onto a cloud. I'm talking about that phone.
So the old phone, yes.
Yeah, it's just everything on it's destroyed, correct?
Right, although some of the data transfers to your new phone.
And you're aware that the very data that you were ordered to preserve would have been destroyed, according to you, the day before. Correct?
Rephrase your question or ask me a question.
If your Are you claiming that you got rid of your phone on the 22nd?
I upgraded my phone around that. I'm not sure if that's the exact date, but yes.
So it could have been after the 22nd.
I don't think it was after the 22nd.
Could have been the 24th?
No.
Could have been the 25th?
No.
So you're absolutely sure.
So it was around the 22nd, but it was not the 23rd. It was not the 21st, but it was around the 22nd. So it was the 22nd? No. So when was it? It was around the 22nd. It was not the 23rd? Definitely not. It was not the 21st? Definitely not. So it was the 22nd? Well, around the 22nd. It's like talking to a wall. It's like playing tennis with a wall. It's just no matter how hard you try, it's like, well, I'm just going to bounce it right back to you.
That you could not have upgraded your phone and gotten rid of it anytime after the 23rd when this judge ordered
Gaslighting at its finest.
that it be preserved.
No.
Because you know that if you got rid of that phone after you had been notified that you were ordered by a court to preserve it, you'd be committing a felony.
Objection, Your Honor.
Sustained.
It's true. And he knows it.
So you now claim that you got rid of the phone on September 22nd, 2022. Hours before you were ordered to preserve it. That's your testimony, correct?
Yes.
Is that just a coincidence?
September 4th was my birthday. The phone was broken and failing. I had planned on getting a new phone, and that just happened to be the day that I got it.
Happy birthday. Was that a coincidence?
Objection.
Sustained.
Answer doesn't matter. The question, the jury heard. That's all that matters.
Are you saying that from your closed and locked phone, you inadvertently tapped your phone one time, and that initiated a butt dial to Brian Higgins?
Objection.
Is that what you're saying?
No, that's not what I'm saying.
Tell me what you're saying.
I
How did you butt dial Brian Higgins?
I don't know.
22 in the morning.
I don't know that the phone was locked. I could have been looking through my phone. I butt dial people often and make inadvertent calls. I could have hit a last call from him by accident, thus calling his phone.
So you were actually awake and on your phone at the time.
I was awake, and I could have been looking at my phone.
So, Mr. Albert, how'd you miss the call 17 seconds later?
Well, my wife was in the room with me, and we were hanging out, and I never got the second call from him. So I'm not sure what time he called. I'm not sure what I was doing at that second, but I don't know.
But it didn't go to voicemail.
Well, I didn't get a voicemail from him, no.
So it didn't go to voicemail.
Well, I don't know that it didn't go to voicemail. I just know that I didn't receive a voicemail from him.
So if you, okay.
I mean, we're all guessing here, but I mean, he could have called voicemail.
We're not all guessing.
Well,
here.
you are, because you don't know if he left a voicemail or didn't, or at least got voicemail and then hung up the phone.
Yeah, because you destroyed the phone. You don't know, Jackson. Listen to the cockiness in his voice. I forgot all about that.
I think one of us is trying to guess.
Objection, Your Honor.
Sustained. You know what? I want to see counsel's sidebar for just a second, please.
All right, here we go. This is going to be good.
I'm giving you a lot of leeway with your questions. Please calm down.
Yes, ma'am.
Calm down. Seriously? That's it? And Jackson is smart. He's not going to argue with her. He's like, okay, yes, ma'am. I'll calm down. Whatever. Smart lawyering. Extremely smart lawyering. Have you been injured in an accident? Have you been hurt by a doctor? Have you suffered from a dog bite? Have you lost a loved one due to someone else's negligence? Call us. 1-844-774-HURT. Get a trial lawyer to get you the most money you deserve.
Are you now saying that your phone was open and unlocked at 2:22 a.m.?
I'm saying it could have been.
Are you saying that it was?
I don't know.
Mr. Albert, you were the only person that was there with your phone. Was the phone unlocked, and did you make a call?
Objection.
Can you answer that?
Sure, I don't know.
And 17 seconds later, again, presuming you're the only person there with the phone, did you answer that call?
I did not.
And now we're on to Brian Jr. There's going to be a sidebar here.
When your recollection is refreshed.
Okay, yep.
Does that refresh your recollection as to what you testified to
Sure, yes.
on May 18th, 2023?
Yes.
Isn't it true that you said that the second time you looked out, you saw that there was a black SUV that had pulled forward,
Yes.
but the truck was no longer there?
Sure, it seems like I said that then, yes.
You also testified earlier that you saw tire tracks in the snow, correct?
Yep.
Where were those tracks?
Just along the side towards the driveway along this way, going up towards the flagpole.
And you viewed those tracks kind of leading up towards the flagpole, correct?
Yes.
So you'd agree that the visibility and lighting in front of the house was good enough that you were able to see tire tracks in the snow, correct?
Sure.
But you did not see a 220-pound man lying in the snow in your front yard, did you?
Objection.
Was that something that you saw, so?
No, I didn't see that.
Who was in the house the second time that you looked out the window?
It would have been my mom, my dad, Brian Higgins, my sister, Julie, Sarah, Uncle Matt.
Mr. Albert, you testified on May 18th, 2023
Mm-hmm.
in another grand jury,
Mm-hmm.
and you said, quote, "I'm not sure if Brian Higgins was still there. I know he left at some point." Do you recall that testimony?
Yeah, I know he left my house at some point. I just don't know exactly when it was.
You were asked specifically at the time that you looked out the window who was there, and you said, "I'm not sure if Brian Higgins was there."
Yeah.
Isn't that correct?
Okay, if I said that, yes, because I was not sure. I'm still not sure that if he was there or not.
So you're not sure whether Brian Higgins was there when you looked out the window, correct?
No, I'm not sure.
You have no independent recollection as you sit here today where Mr. Higgins was when you looked out the window, correct?
No.
You also didn't recall Mr. Higgins ever saying goodbye to you or your group, correct?
I believe that's true. Yeah.
In fact, you actually testified before another grand jury on May 18th, 2023, that at some point Mr. Higgins just wasn't there anymore. I must have gone to the bathroom or something. I came back and I said, "Where did Higgins go?" And they said he left, correct?
Sure. Yes.
You also testified before that grand
Objection, Your Honor.
What's the objection?
So, yeah, I'm going to see it, Tybert, if you could bring that, please.
This is impeachment. You're saying one thing today and you said something different in May of 23, 11 months prior or 12 months prior, whatever. Since this is May 2024. What's the problem? This is impeachment. This is classic impeachment.
And statements. Or are you just reading his testimony?
Well, those are prior inconsistent statements
Yeah.
because he said that he just testified that Higgins was there.
Okay. What are you reading now?
I can rephrase it.
Okay. Don't just read that testimony. Okay.
Okay.
All right. Ask the question. And if it is a prior inconsistent statement, then you can impeach him. But don't just read it.
Sure.
I think reading it would be proper, but Canoni doesn't like it, of course. Anything that helps the prosecution, let it in. Anything that helps the defense, do not let it in. That's her motto.
When did your father leave in relation to Brian Higgins?
Leave? You mean like go upstairs, go to bed, or?
Leave your view.
He would have left after Brian Higgins had gone.
Mr. Albert, isn't it true that you weren't quite so sure about that when you testified on May 18th, 2023?
I don't know. You would have to show me.
Do you have a specific recollection of your father leaving after Mr. Higgins was gone?
Yep, I'm pretty sure he went upstairs after Brian Higgins left.
Mr. Albert, isn't it true that you told the grand jury, "I'm pretty sure Mr. Higgins left first before my dad went upstairs because he wouldn't have left if his friend was still there"?
Yes, I just said that here as well.
You don't have any specific recollection as you sit here today where your father was or where Mr. Higgins was when you looked out the window that night,
No.
correct?
No, that's not true. I know that my father was in the room with us. I'm saying I don't know when Brian Higgins left the house. And when Brian Higgins left the house, then my father went upstairs into his bedroom.
But what you actually said was, quote, "I'm pretty sure Mr. Higgins left first before my dad went upstairs because he wouldn't have left if his friend was still there," correct?
I see what you're saying. Yes, but I still say that my dad wouldn't have went upstairs until Brian Higgins left the house.
Right, and that's based on an assumption, correct?
Sure, yeah.
Because you weren't interviewed about this case until 18 months later, correct?
Yeah.
You consider
And there's Caitlin Albert. And this is cross-examination by Jackson. Excuse me, Yannetti.
An acquaintance. How would you define that term?
I would say an acquaintance.
This is about the relationship between her and McLaughlin, firefighter McLaughlin. We just kind of hang out every once in a while when they probably are besties or something.
Someone who you are friendly with and might see from time to time. I guess in my head, I'm just sort of thinking someone who's in closer in age with me. I usually think of it as more of like a friend type thing and not my father's friend to me. I guess that's just the way I think of it in my head.
Okay, so is your testimony before this jury that an acquaintance is really a friend?
Someone that you're friendly with, perhaps. Could be.
Okay.
She appears to be very bemused for some reason, but we'll see. I don't remember the sidebar reference, why we went to the sidebar. We're about to find out, though.
Have you watched any of the testimony in this case prior to your taking the stand today?
I have not.
Has anybody told you anything about any of the testimony that has occurred prior to your taking the stand today?
No.
Okay. Who is Katie McLaughlin?
Katie McLaughlin is a girl who I'm the same age as. We went to high school together. We graduated the same year, and we have a couple mutual friends. We interact with some of the same people socially. I can't think of a time, possibly ever, where her and I ever hung out one-on-one or individually. So more of like a friend of a mutual friend.
That answer, by the way, seems so oddly specific, as if you have been watching testimony and you have been coached on what you need to say. Otherwise, why would she know how to cross all the T's and dot all the I's exactly on an open-ended question? Think about that.
Okay. So, Kate, you would not consider Katie McLaughlin to be a friend?
She's not a close personal friend of mine.
I asked you if she was a close personal friend.
Objection.
Just let her finish her answer.
I'm sorry. Go ahead. Finish your answer.
I would not consider her one of my, again, close friends.
Okay. All right. So let's get back to my question. Would you consider her to be a friend?
Objection.
What?
I'll allow that.
Your Honor, may we approach?
Why, Lally?
Stand up and stretch.
Crazy.
What is the objection?
Your Honor, as it pertains to this witness, I'm not sure what the relevance is of anything to do with her relationship with the firefighter that showed up at her house that morning.
Okay. What do you say, Mr. Yannetti?
What I say is that there has been testimony that she told Trooper Proctor that Katie McLaughlin told Rupert Proctor that my client looked at Jen McCabe and said, I hit him, I hit him, I hit him. Katie McLaughlin then testified before this jury to a brand new conversation that was back and forth involving multiple people. And she has admitted under oath that her testimony evolved, and that she also admitted it evolved after she learned that 34 Fairview was the Albert home. So this is directly on point to impeach Katie McLaughlin's characterization of their relationship as just acquaintances. We have multiple photographs putting them.
I understand. I don't see their testimony as different. Well, it's...
Right, I'm sorry. I cut the cord off.
So I think you've covered the same ground that you are covering, or maybe the end of you covering it. You're just shaking your head. So tell me what it is that you expect to ask of her now.
Okay, so I want to impeach her specifically, saying that she doesn't know. She's minimizing her relationship with Katie McLaughlin. You know, in addition to H, I, J, and K, which were the previous ones that were marked for identification, as I made the court aware, we received multiple photos after that, which were more incriminating in terms of putting the two of them together. They are arm in arm in a lot of photos. They are at a baby shower together, standing right next to each other in a small group. And she is with This witness is with her 2 college roommates and 1 other person, and that other person is Katie McLaughlin. She is trying to distance herself, and it is crystal clear to me that she has either read social media or she has received some information about the cross-examination that
Yep.
Mr. Jackson did of
Yep.
Katie McLaughlin,
Yep.
where there was a big emphasis on her not being a friend,
Yep.
and that
Why is that crystal clear to
That's
me?
so obvious.
There is nothing before me that indicates that.
she used the exact language, which is, I was asking her if she was a friend, and she immediately jumped to, I don't consider her to be a close friend.
Yep.
Which is exactly what Katie McLaughlin said.
Yep.
As well.
Your Honor, it could also just be the truth.
Oh,
Well,
really?
I'm entitled to explore what the truth is or what the truth isn't.
I think we're just about finished with this. I know you feel differently. You don't have to agree with me. I'll give you one more question, but I don't think you're quite.
So I don't get to introduce any of the photos putting them together that depicts the actual relationship?
Not based on what I've seen here. What I'll do tonight is I'll go back through my notes on Katie McLaughlin. But for the same reason that she didn't get it with Katie McLaughlin, I don't see you getting it here. I'll give you 1 or 2 more questions.
Of course.
Rather than take the 1 or 2 more questions, I'd rather move on to another topic and then revisit it tomorrow morning.
Okay? Okay.
Crazy. So freaking crazy.
Okay, Ms. Albert, you know Courtney Proctor, correct?
I know of her, yes.
And you've been in her company several times, correct?
Yes.
All right, folks. I think this is a good place to stop. Again, don't forget to like this video, comment below, subscribe to the channel if you haven't already. Caitlin Albert is done. Brian Albert is done, and their sidebars. Again, shout out to the trial channel, folks. This is crazy. This is just the level of protection that Auntie Bev is trying to allow Caitlin and the Alberts. I mean, she is an Albert. All of the Alberts and later the McCabe's. Of course, we haven't gotten to that yet. Allie McCabe is going to be coming up soon. That's the date I was in court in mid-May of 2024, maybe late May, something like that. 2024. I remember those days very vividly, very vividly. So you're going to see my likeness on your screen in 2 places. You're going to see me on live recording this, and you're going to see past me from 2 years ago in the courtroom. The lengths that Auntie Bev is willing to go to, once again, just nothing shocking, nothing new, nothing surprising. The corruption just continues of, I'm just not letting you, I don't care, nothing is relevant, move on. Anytime that Yannetti or Jackson or Little are trying to get to the truth, they're getting cut off at the knees saying, nope, not for you. Not this time. Not ever. Use it on a different witness. And then the next witness that's supposed to be the next witness where I can get this from. Nope, not relevant. This is not the proper witness to get this from. They're just playing. It's the same crap that bureaucracies play. It's like, no, this is the wrong department. Call that department. Nope, this is the wrong department too. You need to call that department. But that department just sent me here. I don't care. That's your problem. It's the same garbage, the same bureaucratic BS that governments are known for. And here it is in full display. So, folks, I hope you all learned something. I hope you all enjoyed it. We're going to continue with more Caitlin Albert and Julie Nagel in the next video. And until then, folks, I love you all. I hope you learned something. Don't forget to subscribe to our other channels. They're on our main page on YouTube. And I'll see you all in the next video. Bye, everybody.